Welcome to today's program, Recent Developments Regarding Section 230 of the Communications Decency Act. I'm Kevin Vick. I'm an attorney in Los Angeles at Jassy, Vick, Carolyn, and I handle media, IP, and entertainment litigation, and I counsel clients regarding all sorts of content, including online content. Thank you for watching today. First, here's a brief overview of today's program. In part one, we're going to look at Section 230's basic principles of immunity. In part two, we'll look at plaintiffs' common attempts to work around Section 230 immunity. In part three, we're going to look at the California Supreme Court's recent decision in Hassell v. Bird. In part four, we're going to look at new federal legislation, FOSTA SESTA, regarding Section 230 and some limitations on its immunity. And finally, in part five, we're going to look at Section 230 tips and best practices. Starting with part one, Section 230 basic principles. Congress enacted Section 230 in 1996 to avoid chilling online speech. In particular, it was a reaction towards a New York decision which had held that an online bulletin board operator was liable for the defamatory posts made by its users. Now, this was a real concern because even back in 1996, if you were running something like an online bulletin board, you're talking about a massive amount of information, and you're talking about a massive amount of users over whom you don't have direct control. The concern was that if online parties, such as the bulletin board operators, were liable for all of their users' speech, that they would eventually shut down that speech, and that would make it impossible to allow things that now we think of as commonplace on the internet. Now, the key provisions in Section 230 C1, or Section 230 rather, they may look rather innocuous at first blush. The key provisions, there's really two for the purposes of what we're talking about today, which is Section 230 C1 immunity. First, you look at Section 230 C1 itself, and it provides no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. The second key provision in the statute is Section 230E3. And that provides no liability may be imposed under any state or local law that is inconsistent with this section. Now, as modest as those provisions may seem, courts have interpreted Section 230 broadly and consistently held that it provides immunity for online intermediaries. That includes websites, apps, platforms. It precludes liability against them for publishing or distributing other parties' speech. In a nutshell, there's this quote from the Ninth Circuit in a case called Fair Housing Council of San Fernando Valley versus Roommates, where the court says any activity that can be boiled down to deciding whether to publish or exclude material that third parties seek to post online is per force immune under Section 230. This is hugely important because the internet as we know it today, it could not exist without Section 230 C1 immunity. Imagine if Twitter, for example, could be held liable for its millions of users anytime that they posted anything defamatory. What would happen? They'd have to shut it down, or they'd become so restrictive that any time that they received any sort of complaint about speech, the legally safe thing to do would be to just simply take it down, regardless of whether it's defamatory or not. Thinking of other popular websites and apps, think of Facebook or Instagram. If they could be held liable every time that a photo posted by one of their users invaded the privacy of someone else, the liability would be endless. Again, it would snuff what we think of as now as Internet 2.0, relying on user-generated content. It would have snuffed that out in the cradle. What Section 230 has done is given these social media networks, online platforms, and websites, it's given them the legal space in which to operate. Here it's helpful to compare it to the offline world. Think, for example, of offline publishers, for example, a newspaper. If a newspaper publishes someone else's speech, for example, a letter to the editor, or maybe an opinion piece in the Sunday opinion section, they could be sued under certain circumstances based upon that other person's speech. But it's different on the internet. And the reason it's different is because of Section 230. Now, part of what makes Section 230 so effective and so useful for these websites, platforms, and apps is that it provides a very effective legal defense. Specifically, Section 230C1 provides a defense that can be very often successfully asserted at the pleading stage. So that means you don't get into burdensome discovery. You don't have to wait until summary judgment. You have a defense that can be deployed at the pleading stage, whether that's a 12b6 motion, a demur here in California State Court, or maybe an anti-SLAPP motion, depending on the jurisdiction in which you are practicing. Another factor of Section 230, which makes it so useful as a defense, is it's not limited to a specific cause of action only. It's not like the Digital Millennium Copyright Act, which is a defense under certain conditions to copyright infringement claims. Rather, Section 230 applies to any cause of action where the duty that the defendant allegedly violated derives from that defendant's status or conduct as a publisher or speaker of information provided by another person. I've personally handled cases where Section 230 has been used not only as a defense against, say, defamation, which is what people often think of when they think of Section 230, but also claims like invasion of privacy, interference with contract or prospective economic advantage, infliction of emotional distress, Business and Professions Code Section 17200, which governs unfair practices here in California, even negligence. The list goes on and on. It really depends on the reason why the defendant is being sued. Now, another thing that makes Section 230 such a robust and effective defense is it's not subject to any notice and takedown requirement, such as the Digital Millennium Copyright Act that I mentioned earlier. So that means that if a website puts something up from a third party, someone complains about it, the website is not put into a position where they have to decide, do I want to keep my immunity or am I going to take this down? Even if they choose to leave it up, the immunity still remains. Again, that's a key distinction and something that we're going to look at earlier when we start talking about the new federal legislation. Now, there are some exceptions to Section 230. For civil litigation, the most important one I would say is the IP exception. And the scope of that IP exception depends on where you are in the country. In all of the country, federal IP claims are exempt from Section 230 immunity. Now, there are exceptions to Section 230 immunity. The most important one for the purposes of civil litigation is the IP exception. Section 230 immunity is not going to immunize you against IP claims. Now, which IP claims are covered by that can depend a little bit depending on where you are. If you are in the Ninth Circuit, for example, that can mean that federal IP claims are exempt from Section 230 immunity. State IP claims, however, in the Ninth Circuit, those are subject to Section 230 immunity. So if, for example, someone were to sue under California state trademark law here in the Ninth Circuit, those claims would be blocked by Section 230, potentially. Now, in the rest of the country, the rule tends to be different. I believe there was a case out of the Eastern District of Pennsylvania, if memory serves correct, recently that followed the Ninth Circuit, but most of the courts around the country have not followed the Ninth Circuit's rule and have held that this IP exception applies to not only the federal IP claims, but also state IP claims. There are a couple other exceptions to Section 230 immunity. The federal criminal communications, federal criminal prosecutions are not accepted. And then claims under the Electronic Communications Privacy Act also are accepted. And the same goes for state law equivalents there. And the last major exception, and one we're going to talk about in more length later on, is this new federal legislation, FOSTA-SESTA. Now, just because Section 230 provides such a good defense, that doesn't mean that creative plaintiffs' lawyers aren't constantly looking for new attempts to try and get around Section 230. Today I'm going to go through 3 of the most common workarounds right now that are relevant today. That brings us to our first workaround number 1, which is plaintiffs arguing that their claims do not seek to treat the defendant as a publisher or speaker of content from another party, but are instead based on a theory of duty to warn users about the dangers and risks on a website, platform, or app. Now, the duty to warn workaround is popular right now in large part because of a 2016 decision by the Ninth Circuit. That decision was in Doe versus Internet Brands. Plaintiffs hadn't previously focused much on this duty to warn, and the reason why is because there was prior case law, most prominently 2 cases against MySpace back in 2008 and 2009, where plaintiffs had tried to hold MySpace liable where there had been minors on MySpace. They had been contacted by predators over the website, then had met offline in the real world, and the minors had been abused by these predators. Now, in both of those cases, one in the Fifth Circuit, the other in the California Court of Appeal, the courts held that Section 230 immunity protected MySpace and that it applied here. So as a result, you didn't see a whole lot of action in this duty to warn argument for many years. That all changed, however, as you flash forward to 2016 and the Ninth Circuit's decision in Doe versus Internet Brands. Now, the defendant there operated Model Mayhem. That was a networking site for models and photographers where they could post samples of their work and network and try and attract business. This case involved horrific facts. The plaintiff was an aspiring model. She created her profile on Model Mayhem. She posted photos along with her contact information. 2 men in Florida contacted her. They invited her to an audition down there, and when she got there, they drugged her, raped her, filmed it, and then sold it as a pornographic tape. It turned out the plaintiff was not their first victim either. They'd been running this scheme for years. Ultimately, the 2 men were apprehended, tried, convicted, and sentenced to life in prison. Now, the model sued Internet Brands, alleging a claim for negligent failure to warn. One important fact that came out was it turned out that the defendant had actually known about the rapists. During litigation that the defendant had brought against the website's previous owners, the defendant had even complained about the fact that the previous owners had not disclosed the existence of these guys who were running this scheme and contacting people on the website and then luring them in that manner. And the owners of the website, the defendants in this case, they complained that the prior owners had not warned them about it and that this had exposed them that actually could be considered fraud because it could open up the new owners to liability. So the model sued. Internet Brands brought a motion to dismiss and they asserted Section 230 immunity. They argued that the plaintiff was trying to impose liability on them merely as the basis of plaintiffs having posted her information and contact info on their website, and then the rapists down in Florida having contacted her using that contact information. They said, hey, our entire role here is only as an intermediary who provided her information that she'd given online that was then used. The district court granted the motion on that basis. The Ninth Circuit reversed. The Ninth Circuit said no Section 230 immunity here. The primary reason was the court said that the plaintiff did not seek to hold the defendant liable as a publisher or speaker of content posted by another party on the website. The court reasoned that the plaintiff was not claiming that the defendant should have never posted her profile or should have taken it down. The court also relied heavily on the fact that the rapists themselves had not posted on Model Mayhem. They, unlike the MySpace cases we discussed earlier, they had not been using the platform in order to communicate with the plaintiff. Rather, they got the contact information, and I think what it was is they used just a simple old-fashioned phone to call her. The court also rejected the defendant's but-for argument. And this may be the most interesting aspect of the decision going forward. Now, the but-for argument goes like this. But for a defendant's website serving as an intermediary between the plaintiff via her profile and the rapists, there could be no liability against the website. The Ninth Circuit held that that was just too attenuated. The court stressed also that the website's knowledge about the rapists, it didn't come from based on the content that was there online. It did not require the website in any sense to be monitoring the online postings. Rather, their knowledge of these guys came from offline sources. The court really relied on that pretty heavily to distinguish the two MySpace cases we talked about before. Now, some takeaways from Doe versus Internet Brands. First of all, Section 230 has its limits. As the claim states, the plaintiff's, as the statute states, the plaintiff's claim has to treat the defendant as a publisher or speaker of other parties' content in order to qualify for Section 230 immunity. More attenuated but-for arguments, they may not cut it. Second, in particular, they may not cut it, and narrower interpretations of Section 230 may win out where there are bad facts in the case. Now, this case involves some of the worst facts one can imagine. That said, Section 230 cases often involve, if not facts that bad, but facts that can often be pretty bad. Here, you went even beyond bad facts in a sense, in that you had what the court, I think, viewed as hypocrisy from the defendants. Namely, on the one hand, they're suing the former website owners for having failed to warn them about the existence of these guys out there preying on Model Mayhem users like the plaintiff. On the other hand, they're claiming that there should be no duty to warn her. That may have been a bit much for the court to swallow. And so in this case, they interpreted Section 230 more narrowly. Now, the result is that this failure to warn theory, it's opened up a bit of a potential breach in Section 230 immunity. And there have been a number of copycat suits since then, including ones against online dating websites, saying that those websites, in addition, had failed to warn their users about the dangers of other users. That said, most of these lawsuits, including actually Doe versus Internet Brands, have ultimately failed. Now, either, as in the case of Internet Brands, for other legal reasons not having to do with Section 230. In that case, what it came down to was the plaintiff was simply unable to establish a basis for a legal duty, a cognizable legal duty for a duty to warn under the circumstances there. And state law action can be quite stringent, quite tough to meet in order to establish a duty to warn on behalf of the defendant. Now, second reason why some of these lawsuits fail is because other courts have interpreted Section 230 more broadly than Internet Brands, or they've distinguished Internet Brands based on the particular facts of the case. And again, the facts of Internet Brands sort of lend themselves to distinguishing. First, you have the rapists. They did not communicate with the plaintiff via the Model Mayhem website. That's going to make things quite different from a number of these other situations. For example, there you could imagine a dating website. If people are communicating, they're communicating through the app, not outside. Second, the website here, they had special knowledge that emanated from offline, knowledge that was not based upon them having to monitor and know what was going on with the content being posted by the users. That brings us to the second workaround that we're looking at today, and that is an argument that the defendant website is responsible, at least in part, for creation or development of the third-party content at issue. Now, again, your immunity under Section 230, it's for content that's provided by another person. If the website itself puts that content up, then Section 230 doesn't apply. It's not, that just is not what it encompasses. Now, in the past, some plaintiffs have tried, with scattered success, to blur the line between a platform's speech and the speech of its users by relying on theories of encouragement and ratification. The idea there would be that the website may have not authored the speech, but they'd encouraged, either explicitly or implicitly, their users to post wrongful speech, or they'd ratified that speech by keeping it up on their website even after they had received notice of its actionability. Now, The key example here, I think, probably the best example, is this case that came out of the Sixth Circuit. It was brought against the operator of a website called The Dirty. The Dirty invited its users to post dirt on celebrities and others. Now, after certain users posted libelous comments about a Cincinnati Bengals cheerleader and the website refused to take it down, she sued the website. She won at the trial court, who had rejected the website's Section 230 defense, but she lost on appeal. The Court of Appeal there said that, even encouragement and ratification, that could not vitiate Section 230 immunity. Immunity was lost only if the website itself played a hand in the development and creation of the aspect of the speech that was illegal. Now, this is an important point. It's not enough that the defendant website have contributed in some way to, say, somewhere in the one-page post that someone puts up. What's needed, as the Ninth Circuit held in Roommates, is that the website or platform must contribute materially to the alleged illegality of the content. For example, the portion of a one-page post that contains the allegedly defamatory statement. Now, The Dirty sort of seemed like the end of these encouragement and ratification type theories. And this was not lost on attorneys out there who were bringing claims and wanted to steer clear of Section 230 immunity. So in response to decisions like Roommates and The Dirty, you started to see plaintiffs alleging, often in a quite conclusory manner, that the defendant platform or website helped to create or develop the objectionable content. A key issue became after that, how closely would courts scrutinize allegations that a defendant website helped to create or develop actionable content? Would it be the sort of thing where if the plaintiff just sort of says the magic words, they get past the pleading stage, they get into discovery and forward, or would the court scrutinize it more closely than that? Now, this brings us to the Seventh Circuit's decision in Huon versus Denton. This case involved the comments section of an article on the website Jezebel.com. The comment in question provided, "She jumped out of a moving car, leaving her shoes and purse behind, and ran barefoot through a cornfield and pounded on a stranger's door to help her. Fuck this, he's been acquitted noise. He's a rapist, all right, so we may as well call him one." Now, this case got all the way to a fourth amended complaint. And in that fourth amended complaint, the key allegation which kept the case alive, or which the plaintiff was hoping would keep the case alive, was an allegation that the website's employees themselves had supposedly authored some of the comments. The district court, however, granted the defendant's motion to dismiss. It held that those allegations were too conclusory and were legally insufficient to avoid Section 230. As you might imagine, the district court relied on the recent Supreme Court decisions of Twombly and Iqbal regarding pleading and plausibility. On appeal, however, the Seventh Circuit reversed. Now, the Seventh Circuit reasoned as follows. They said, "We see nothing far-fetched about Huon's factual allegations. In particular, his contention that one or more of the comments were authored by Gawker employees." Again, another quote from the Seventh Circuit. "Critically, the complaint hints at why Gawker employees might have anonymously authored comments. To wit, to increase traffic to Gawker's websites. And second, there'd been a Reuters article that had explained precisely how Gawker was planning to monetize its comments." Now, this was a disappointing decision for defendants. It provides a roadmap for plaintiffs, at least in the Seventh Circuit, and it may give pause to district courts who would otherwise be inclined to rely on Twombly and Iqbal to root out claims based on conclusory allegations. One particularly frustrating aspect of this decision was the Court of Appeals' failure to address the fact that while the plaintiff alleged that Gawker employees had authored, some of the comments underneath the article, there were many, many comments, there was not an allegation tying the Gawker employees to the actual comment, the sole comment that the Court of Appeal held might be actionable, the one that we looked at earlier. Under, I think, the better understanding of Section 230, you need at least that sort of tailoring. If you're going to be relying on the website's creation and or role in the creation and or development of the content, it's got to be a role of creation or development in the actual aspect of the content that is allegedly wrongful. So that's one side. On the other side, you have a case that came out not around the same time. Again, this was 2016 from the Ninth Circuit, Kimsey v. Yelp, that had better news for websites and Section 230 defendants. That case had some similar facts. It involved negative comments on Yelp about a plaintiff's locksmith business. The plaintiff had made some allegations similar to those in Huan regarding defendants' alleged role in the comments. That said, the allegations were not set forth quite as cogently and lucidly as in Huan. In Huan, the plaintiff was an attorney, so they were able to plead it, much more effectively. Regardless, in Kimsey, both the district court and eventually the Ninth Circuit, they rejected those allegations. What they said was threadbare allegations of fabrication of statements are implausible on their face and are insufficient to avoid immunity under the CDA. And they cited Iqbal. They also sort of just appealed to practicalities, saying it cannot be the case that the CDA and its purpose of promoting the free exchange of information and ideas over the internet could be so casually eviscerated. Another aspect of Kimsey that's useful potentially is they said that aggregate rating systems, here Yelp's star system, that constitutes user-generated content, and thus you cannot be sued based upon that. So that even though the users may each individual review, they may give 1 star here, 3 stars here, 4 stars there, the aggregate rating provided by Yelp will be treated as user-generated content. So a couple quick takeaways from Huan and Kimsey going forward. First, be happy if you're defending in the Ninth Circuit. That's strange. That's not what you normally think, but in this case, it's quite true. Second, opportunistic plaintiffs sometimes evade Section 230 at the pleading stage. But one thing to keep in mind, there can be other tools to combat that. In some jurisdictions, such as California, you have an anti-SLAPP statute, and that can help substantively challenge the truth of allegations right out the gate. Also, a thing to consider is bringing a Rule 11 motion, particularly if the other side is represented. It may be less effective if you're dealing with a pro se plaintiff, but if they have an attorney, they may pause at just sort of conclusorily alleging that the defendant website, authored the comments at issue. Finally, it's important to keep in mind other defenses. For example, in a defamatory context, is it an opinion? Is there really defamatory meaning? Is there some privilege that might apply, like the fair report privilege? Are there problems in the claims? Just because Section 230 gives you this quick, effective defense, don't give short shrift to the others. So far we've looked at the failure to warn workaround, and we've looked at the creation and development workaround. That's going to bring us to the third workaround we're focusing on today. That is the facilitation workaround. Here, what is argued is that a defendant website or platform should lose its immunity because the structure and design of the site somehow facilitated the illegal conduct of users. And this happens when you can't point to specific speech that you could say that the defendant had authored or played a part in creating or developing, but you are arguing that the overall sort of structure, the design, maybe the way the pull-down menus are working on the website, that somehow those should render the website liable and outside of Section 230 immunity. A good example of this is the decision by the First Circuit last year in Jane Doe No. 1 versus Backpage.com. I think this is a good example because it is a case which, again, it involved very sympathetic plaintiffs, an unsympathetic defendant, and if there was going to be legs for this, design, structure, facilitation argument, you would think, well, this is the sort of case where a court might pick up with that and run with it. But they didn't. So first, a little background about the case. Defendant Backpage.com, it was a classified website. It was sort of formatted like Craigslist, but it catered significantly to adult content, including ads for escorts. The plaintiffs were 3 young women who claimed that they had been trafficked and raped as prostitutes when they were minors, and they claimed that they had been trafficked via ads that appeared on Backpage.com. So the plaintiffs sued Backpage for sex trafficking and other claims. They alleged that Backpage had structured its website to facilitate sex traffickers' efforts to advertise the women in order to minimize those traffickers' legal risks and to maximize Backpage and the traffickers' profits. To give you an idea of how the argument went, they really alleged that Backpage was encouraging and facilitating sex trafficking in the following manners. First, by not requiring phone numbers or email verification for those posting the ads. Second, by allowing users to hide email addresses in postings because Backpage provided a message forwarding service. Third, by removing metadata from photos to prevent investigations regarding time and place those photos were taken. Fourth, via inadequate filtering so that while posts with, for example, the word high school would be rejected, if someone just sort of misspelled that and said hi, SCHL, that would slip through the filter. Fifth, by only charging for ads in the adult entertainment section, the other sections were free. The district court rejected the plaintiffs' arguments and held that Section 230 applied and immunized Backpage. The First Circuit affirmed on appeal. The First Circuit held that Section 230 applied because it immunizes Backpage for decisions regarding website features that are part and parcel of the overall design and operation of the website, such as the lack of phone number verification, the rules about whether a person may post after attempting to enter a forbidden term, and the procedure for uploading photographs. Now, compare this result with another decision involving an almost identical set of allegations against Backpage that occurred in Washington's Supreme Court. There, the court reached the opposite conclusion. The court denied Section 230 immunity to Backpage. Similarly, a Wisconsin state appellate court very recently held that that Section 230 did not immunize a website for claims based on carrying advertisements for guns that were later used in a mass shooting. Now, one key difference to keep in mind, in Washington and Wisconsin, the state judges are elected, in contrast to the Ninth Circuit where they're not. And this will come up again when we start talking about FOSTA and SESTA and differences there. Now, some takeaways from Backpage.com. First, if you are a defendant in a Section 230 case and you've got some bad facts, that case is a good one to cite in terms of, even as bad as the facts are, the law is what it is. An argument along the lines of, even in cases as extreme as this, pointing to the Backpage decision, even under those horrific circumstances, courts will apply Section 230 where the elements for the immunity are met. A second takeaway, the website's configurations, settings, and design, that those are editorial decisions protected by Section 230. And that's important because a decision whether or not to allow third-party content to be posted online or to decide to remove it after it's been posted, those are pretty easy to understand. Those are editorial decisions. But if you're going a bit further, if you want to say that the way that it's designed, that the way the website is laid out, that's also subject to Section 230. This is a good case for you. Another thing is Section 230E1, which has an exemption for federal criminal prosecutions. That only applies in those criminal cases. It does not apply to civil lawsuits that are predicated based on alleged violations of federal criminal law. Now, as a postscript, in April 2018, the US government shut down Backpage, and it indicted a number of the people who were involved in running Backpage for facilitating prostitution and for money laundering. And Backpage's former CEO even subsequently pleaded guilty. Now, as a result of Backpage and all of the controversy surrounding them, in part, on April 11th, 2018, President Trump signed H.R. 1865, the Allow States and Victims to Fight Online Sex Trafficking Act of 2017. Now, that is the FOSTA SESTA statute that I've been referring to throughout this program and that we'll be looking at in a bit more detail later. Another area in which you've seen these facilitation arguments be attempted but ultimately generally fail has been in the context of social media platforms where their users have either posted extremist content or terrorist organizations have used the platforms to communicate with each other and to try and coordinate terrorist actions. A couple examples of that include Fields v. Twitter. That was in the Northern District of California. The family of American contractors killed by Jordanian police linked to ISIS had sued Twitter for allowing ISIS to use Twitter. The district court rejected that suit on Section 230 grounds, saying you could hold the people who posted it, who used Twitter, the users themselves, you could hold them liable, but you can't hold Twitter liable as the intermediary. Similar result was reached in Cohen v. Facebook. That was in the Eastern District of New York in 2017. There you had 20,000 Israeli citizens suing Facebook for allowing Palestinian terrorist groups and their members to use Facebook. But courts under these sort of sets of allegations, they've consistently held that Section 230 immunity applies. That said, while these cases have failed in American courts, it's very important when thinking about these issues to recognize and acknowledge that it's not just American courts that you necessarily need to be focused on. Sometimes the bigger threats to the websites, the apps, the platforms come from abroad in the form of foreign regulations and foreign lawsuits. Other countries don't have Section 230. I read that the recent, I can't remember the acronym, it's the replacement for NAFTA that the US just entered into with Mexico. I've read that Section 230 was a part of that. So it looks like perhaps with regard to interactions with Mexico, there may be some protections along the line of Section 230. But in other jurisdictions, that is definitely not the case. You look at Theresa May, the Prime Minister of the UK, she had this quote from last year: "We need to work with allied democratic governments to reach international agreements to regulate cyberspace to prevent the spread of extremist and terrorism planning." And under German law, current German law, the platforms, if they leave forbidden content up for more than 24 hours after notification, they can face fines of up to 50 million euros. And this may be calling to mind for some of you the right to be forgotten. People have, the right to be forgotten, for those of you who aren't familiar, it's a right that exists in the EU and in certain other countries around the globe that gives individuals under certain circumstances the right to demand that internet search engines de-index certain results. For example, a result about them from 15 years ago, about certain things. And in some cases, some courts have suggested that it may even give a right to go into the archives for online newspapers and to remove articles from those archives, at least in those jurisdictions. Now, I'm sometimes asked if there could be a right to be forgotten in the United States. My answer is no, there couldn't, really for two reasons. First is Section 230, what we've been looking at. The second reason would be the First Amendment, which I think even in the absence of Section 230 would provide certain protections against that. But for anyone who's publishing in this day and age, they're very likely publishing not just in the, online, they're not just in the United States, they're around the world. So it's important to consider where your audience is, where the subjects of your stories are from, and to keep in mind issues of international law which may differ from the United States. That brings us to part 3 of this program. And that is what was probably, if not certainly one of the most closely watched and anticipated decisions regarding Section 230 in this year, 2018. That's the California Supreme Court's decision in Hassell v. Byrd. Now, first I'll give you some of the facts of that case. What happened there was a law firm sued an ex-client based on negative Yelp reviews that the client had allegedly posted about the law firm. Now, the firm obtained a default judgment against the ex-client. As part of that default judgment, they got, I think it was about $550,000 in damages, and also an order requiring the ex-client to remove the Yelp reviews. Now, that order went one step further, and it also required non-party Yelp to remove those reviews if the ex-client failed to do so herself. As it turned out, the ex-client did not remove them. After Yelp and the plaintiff's attorneys began communicating, Yelp actually went into court and sought to bring a motion to set aside and vacate the judgment. Among other things, Yelp argued that the order requiring it to remove the ex-client's reviews violated Section 230. The trial court, however, rejected Yelp's Section 230 arguments, as well as its other arguments. So did the Court of Appeal. So after the Court of Appeal had rejected Yelp's appeal and it held that Section 230 did not help Yelp, the case went to the California Supreme Court. Earlier this year, the Supreme Court issued its ruling. Chief Justice Kantil Sakauye, writing for herself, two other justices, and with Justice Kruger concurring, held that Section 230 barred the injunction takedown order against Yelp. Now, what they said is that Section 230 immunity applies to requests for injunctive relief, not just causes of action and requests for damages. That is an issue on which they parted ways with the dissenters. We'll speak about that a little bit more when we get to the dissenters. The majority here also held that Section 230 immunity, it applies not just to parties to the litigation, but also to non-parties in Yelp's position. The court also expressed concern that any contrary result, that a ruling that Yelp did not have Section 230 immunity, that would incentivize plaintiffs in the future to deliberately omit platforms like Yelp from the litigation in order to achieve an end around Section 230. Along the same lines, the court cited an amicus brief written by Professor Eugene Volokh regarding bogus court orders and other shady tactics that had been used in order to evade Section 230 in a number, I believe it was many dozens of cases around the United States. Professor Volokh, along with Paul Allen Levy at Public Citizen, they've been instrumental in exposing significant amounts of fraud and other misconduct related to certain illicit efforts to avoid Section 230 immunity. Those have included forged court orders. People have gone to platforms, like a Twitter, like a Facebook, with what was supposedly a court order, but which in fact had been completely forged, and presented that to those platforms, then seeking them to get takedowns that way. Besides that, there have been forged stipulated judgments. So for example, a plaintiff sues a defendant, files with the court, maybe after not even serving the defendant in the first place, but files with the court what purports to be a stipulated judgment in which the defendant agrees to take down the posts and includes an order against the platform to actually take down the posts. People relied on that. Now, there were also lawsuits that were brought and defaults obtained against bogus defendants or even colluding defendants. So instead of suing the person who actually posted the thing online, you sue someone else who then pretends to be the person. And part of the reason why that's so possible is because often the usernames will be something silly and whimsical rather than someone's actual identity, as on maybe Facebook. There can be other websites where it could be anything. And saying who is, 1234 fan number 1, who can say that? So if you have someone who is willing to collude with you as a defendant, you could get them to say, yeah, you're right, it's wrong, I'll take it down. So that was one of the concerns that the majority had as well. Now, as I said, this was not, just a totally clean 4-3 decision. It was more of a 3-1-3 decision. Now, with the one being Justice Kruger, who concurred. Now, she agreed with the plurality on Section 230 in this case, that it applied here and that Yelp should have been immune under Section 230 from that takedown order. But Justice Kruger was generally more focused on non-Section 230 related legal problems with the injunction. And Justice Kruger was also a bit more reluctant to opine definitively regarding Section 230's application in other cases and under circumstances that were not before the court there as they were with Yelp. Now, in addition, there were 3 dissenters. There were 2 dissenting opinions. The one that's a bit more interesting from Section 230 point of view is the one by Justice Cuellar, and that was joined by Justice Liu and Court of Appeal Justice Stewart, who was sitting there by designation as there was a vacancy up on the Supreme Court. Now, what they believed is that Section 230 should not bar injunctive relief against Yelp. They were looking at the language in the Section 230 statute about liability and saying, well, injunctive relief isn't liability. We think that should be interpreted only to apply to claims for damages, monetary, financial damages, not just injunctive relief. That's an opinion that's pretty out of step with the jurisprudence on Section 230 across the country, not just in California, the lower courts, and ultimately in the Supreme Court in this decision, in the majority, but also courts in other jurisdictions who've generally said that Section 230's immunity should also apply to injunctive relief. Justice Cuellar also stressed the fact that the trial court had actually adjudicated the defamatory nature of the post, so that this was not an instance where it had just been alleged, where Yelp was just being told by someone complaining, hey, they're lying about me. What Justice Cuellar said is, you don't have to take the plaintiff's word for it in this matter, because a trial court actually adjudicated that, and that should make it different. A related concern that Justice Cuellar expressed was that the plaintiffs would be left with no remedy. That if, for example, you couldn't locate a defendant who'd actually posted the material such that you couldn't, bring contempt proceedings against that plaintiff for failure to abide by the takedown order, that effectively the plaintiff would have no recourse and that a statement that had been adjudicated as defamatory by a court would nonetheless remain up on the internet. Finally, Justice Cuellar had some language about what would constitute aiding and abetting by the platform. That language was really quite expansive. We'll see if anything comes of that in the future. It may. Frankly, I think we're going to see more litigation in this area, at least in California, in light of Hassell v. Byrd. I mean, you have 3 justices on one side, 3 justices on the other. You have a concurring justice who found for Section 230 immunity in that case, but who was reluctant to set forth, definitive guidance for certain other situations and cases on a going forward basis. So that's one where we'll have to look for future development under the law. That brings us to part 4 of the presentation, which is this new federal law, FOSTA-SESTA. As I mentioned earlier this year, President Trump signed the law, and it has been in effect. Its goal was to target online prostitution and trafficking. I think in particular, one of the core emotional appeals for the law had to do with the widespread trafficking of minors and the prostitution of minors. Now, what FOSTA-SESTA did is it created new federal criminal offenses for owning, managing, or operating an interactive computer service with the intent to promote or facilitate the prostitution of another person or conspiring to do so. It also created a civil cause of action for persons injured by violations of that new criminal statute. In addition, and this is what we're most focused on today, FOSTA-SESTA provides that Section 230 immunity does not apply to certain criminal charges and civil claims. Finally, FOSTA-SESTA applies retroactively. Now, the Department of Justice has raised some concerns regarding the constitutionality of that provision, but as it stands right now, that retroactive provision is in the statute, and it has not been struck down as of yet, so that's something else to look for. Now, in terms of the immunity and how FOSTA-SESTA changed Section 230 immunity, there was a recent decision by the District of Columbia Federal District Court there in Woodhull Freedom Foundation versus United States, where they really kind of summarized what are the differences that FOSTA-SESTA has created in the law of Section 230 immunity. Those differences are fourfold. First, FOSTA makes clear that Section 230 does not preclude civil claims by victims against perpetrators and persons who received anything of value from participation in a sex trafficking venture under 18 U.S.C. Section 1595 if such participation was knowing. Second, Section 230 does not foreclose state criminal prosecution if the conduct underlying the charge would have violated 18 U.S.C. Section 1591. Third, Section 230 does not preclude state criminal prosecution if the conduct would constitute a violation of 18 U.S.C. Section 2421A, the newly created FOSTA criminal offense. Fourth and finally, FOSTA authorizes state attorneys general to bring civil actions in parens patria on behalf of residents of the state who have been threatened or adversely affected by any person who violates section or 18 USC section 1591. Now, in Woodhull Freedom Fund, the plaintiffs, including the Electronic Frontier Foundation, they brought a First Amendment challenge to the constitutionality of FOSTA SESTA. However, the district court recently dismissed that suit based on a lack of standing. Now, you still may be wondering, why does FOSTA SESTA matter that much? I mean, you may think, okay, for a website like Backpage.com that's sort of engaged in a relatively fringe activity and specialty, sure, you can see it's an obvious concern for them, but what does this have to do with the wider internet? Now, this gets to really what was, I would say, the principal criticism of FOSTA SESTA, and that was that it could potentially apply not just to websites that were particularly focused on things like ads for escorts, but to any website that allows user-generated content. Because if a website is allowing its users to post content, those users, they can post anything. They could post cat videos, they could post political screeds, they could post sports scores, or they could post information about prostitutes and how to find them. For example, to see why this was not just a sort of hypothetical concern, shortly after FOSTA SESTA was enacted and became law, Craigslist shut down its personal section in the US. Still available in some other countries, but Craigslist, they showed that this wasn't just something they were theoretically concerned about, but something which they were worried about enough that they shut down their entire personal section. A number of dating websites did the same. They shut down. They were too concerned with this. And in part, this is because FOSTA SESTA bases liability on, quote, knowingly assisting, supporting, or facilitating sex trafficking. This reintroduces a knowledge element into content moderation that Section 230 had pretty much done away with. This is when we talked about how the issue of sort of notice and takedown, there was no requirements there. And between Section 230 and the subsequent case law, it had done away with that such that the websites could do so. They could monitor, they could not monitor, but either way, they would not lose Section 230 immunity. And this has reintroduced what Professor Eric Goldman, who's a noted internet scholar and someone who is focused a lot on Section 230 and whose blog I would recommend highly for anyone who gets interested in Section 230 law, what he has called the moderator's dilemma. And that runs like this. If you have a website and you choose to moderate user-generated content, that can lead to knowledge of conduct that potentially could be related to sex trafficking. If, however, you have your website and you choose not to moderate, sort of hear no evil, see no evil, that could negate the possibility of such guilty knowledge. So what that does is it provides an incentive and encouragement to websites not to moderate. This really sort of flips Section 230's original purpose on its head, which was to avoid the situation that was faced in that New York case that I mentioned at the outset about the bulletin board, where the bulletin board was concerned that if it took some steps to try and moderate content, to try and take down stuff that just looked objectionable and awful, that then they'd be held liable for any shortcomings in their efforts. And that as a result, it was better off just don't moderate anything. So that's been one concern, is that this may have now given an incentive to websites to take a more hands-off approach. Now, and the other primary concern with FOSTA SESTA that's been raised has been, will it embolden Congress to enact more exceptions? It's just the first. Right now it's sex trafficking, which of course is, obviously something that everyone or the vast majority of people are going to be concerned about, particularly when it has to do with minors and sex trafficking against people's will. Is this going to be the camel's nose under the tent, and now are we going to see every year or two additional exceptions to Section 230 immunity? Now, this brings me to the final part of today's program, and that is Section 230 tips and best practices. And this is really, some of these are tips for litigating cases where you might have Section 230 as a potential defense. Other of these are tips for someone who's running a website, an app, or a platform in terms of trying to figure out how they want to moderate. My first tip, and this one's going to sound weird at first, is don't promise to take down user-generated content. Now, that may seem counterintuitive, but the Ninth Circuit's decision in Barnes v. Yahoo will show you why it's not. There, a woman called Yahoo She complained about a fake profile that her ex-boyfriend had posted on Yahoo Personals. Now, the Yahoo employee promised that Yahoo would take it down promptly. Unfortunately, the employee didn't follow through, and the profile remained available online for months. The woman sued, and while the Ninth Circuit held that a number of her claims were barred by Section 230, it also held that her promissory estoppel claim was not. The court reasoned that that claim was not based on Yahoo's duty as a publisher, in terms of its editorial decision whether or not to take down or to leave up any sort of content, but rather on an independent duty stemming from the promise made by the Yahoo customer service person to her over the phone. Now, with that said, it's okay to actually take down the content. If there's stuff up on the website, and it, for example, sometimes it doesn't meet with a website's terms of service, websites very well may want to take down content. But what I would say is that it's dangerous to promise to do so, because if, God forbid, something slips through the cracks, you don't follow through, you don't follow up, you can be on the hook under that Barnes v. Yahoo case. Now, if you wanted to be really thorough, you might even consider putting something in your terms of service along the lines of that no promises will be made to take down user-generated content, and that any purported promises that are made are without authorization of your website. I don't know whether that ultimately would get you off the hook if you face another Barnes v. Yahoo situation, but it's something to consider in terms of making it clear what the organization's terms of service and practices are. Now, a second thing to be concerned about is required fields and pull-down menus with pre-populated options for answers. The reason that's a concern is that can make you a creator or developer of the content. That is what the Ninth Circuit held in that roommates case that I mentioned earlier. There was a roommate matching service, and it required users to specify which races, genders, and sexual orientations they would be open to having as roommates. The court held that in doing so, the website potentially helped develop the illegal, i.e. the discriminatory, content. So with there, you just want to be careful. If there's pull-down menus, if there's, particularly with the pre-populated answers, be careful. If there's any sort of argument that you are somehow requiring or perhaps even forcing your users into providing answers that are in somehow actionable, then that could vitiate the Section 230 immunity for your website or platform. Okay, continuing with the tips and best practices, here's a third tip. If possible, if you're a defendant interested in asserting Section 230 as a defense, you're better off doing so in federal court if you possibly can. In my experience, federal judges are simply much more familiar with Section 230 issues. In addition, maybe because they have two young law clerks who are most likely fresh out of law school and may have been interested in taking an internet law course, there may be that familiarity as well with Section 230 as a defense. I think particularly it can be helpful when used in conjunction with Twombly and Iqbal having to do with your 12b6 pleading standards. If your goal is to rely on Section 230 in hopes of getting a complaint dismissed early, without leave to amend, so that you're not in one of these situations where the court's giving a plaintiff 3, 4, 5 chances to amend the complaint to try and plead around Section 230. Fourth, regardless of whether you are in state or federal court, make sure you educate the court about Section 230's history, its principles, the underlying policies. Section 230 can come across as pretty counterintuitive at first for a number of reasons. In the offline world, for people who are more familiar with publishing in the offline world, like newspapers, it can seem strange, the idea that these platforms are not liable at all, because after all, if you're a newspaper and you have your letters to the editor, that, under certain circumstances, you can be on the hook for too. But Section 230 treats that differently. Second is something as simple as nomenclature. Section 230, it's part of the Communications Decency Act. So when you're using Section 230 to try and argue that you're not liable for some content that may itself seem rather indecent, that may be something that a court has trouble getting its head around at first. So these are all reasons why you want to give, you don't just want to state the rule and say, okay, here are the requirements for Section 230, 1, 2, 3, I'm going to march you through, they all apply here. Give him a sense of, give the judge a sense of why she or he should want to apply Section 230 here, of why the policies make sense, of the reasons why Congress enacted Section 230 in the first place, of how Section 230 has given birth to the internet as we know it, how you couldn't have Facebook and sharing photos with your family members everywhere. You couldn't have these dating websites that have led to, who knows at this point, hundreds of thousands, if not millions of marriages. You couldn't have these things in many ways if you did not have something like Section 230 immunity, and why it's essential that the internet functions that way. Another thing I would always recommend stressing is Section 230 does not preclude plaintiff from bringing any claims at all. It merely means you can't sue the intermediary website, platform, or app. However, you can still sue the speaker itself, the person who actually posted the content. Finally, I'd also suggest that you consider raising Section 230 in less obvious situations in which user-generated content and speech is at issue. Everyone always thinks about Section 230, I think most commonly in connection with defamation claims. And it's a good defense there. That's one of the reasons what it was designed to address. But think about other situations. For example, one area right now that's a developing area in the law, you've seen courts come out in different ways, is online marketplaces. You had a decision in favor of eBay many years ago here in California state courts that held that eBay did not lose its Section 230 immunity based upon allegations that eBay had failed to verify the seller's representations. Now, more recently, you've had cases rejecting Section 230 immunity on behalf of Airbnb, where there was some similar, maybe not exactly the same, but some similar type of allegations. So these online marketplaces, or online places where you're sort of connecting sellers and buyers, those are areas to look out for and see how the law develops in that area. Another thing I would recommend is, think of it again for state IP claims, at least here in the Ninth Circuit. For example, state trademark claims, trade secret claims, or right of publicity claims, which are pretty prevalent right now as well. And another thing to keep in mind is Section 230 immunity, again, it's not limited to only certain causes of action like defamation. It can apply to any cause of action, regardless of the label, so long as the thing for which the defendant is going to be held liable is some sort of its role as a publisher or speaker of content provided by another party. So those are my tips and practices. I'd love to hear feedback, and thank you very much for your time and attention today.